Court rise.
Yes. My lord, my lady, I have 4 points to pick up from yesterday.
Yep.
Before I finish off my...
Sorry, just one moment. Oh, sorry. I didn't allow it to be called on. My clerk reminds me. We should do that for form's sake. We'll wait for your 4 points in a minute. You'll do it very nicely.
Appeal in the matter of bench development, Smart, Manchester Limited and others, and Commissioner for the HMRC and Customs.
Thank you. Yes.
The first point was my lady's question as to the basis for Regulation 9. My submission is it would be Section 71, which you can find behind tab 1, page 29. And that says HMRC must make regulations with respect to the collection and recovery, whether by assessment or otherwise, of sums required to be deducted. My submission, it is a provision with respect to collection and recovery. I believe my learned friend may lean more towards Section 73. Having had a brief discussion with him, although obviously he'll explain his.
Can we just, while we're on that, just look at Reg 9? Something when we were looking at it before, it's just another loose end. I don't think really matters, but I used to feel firm ground to my feet. Isn't the title to it rather odd? I remember thinking this when I listed it first. Recovery from subcontractor of amount not deducted by contractor.
Where's that, my lord?
Reg 9.
Oh, Reg 9.
Because surely the subject matter is the non-recovery from the contractor of amounts prima facie deductible. Or am I being just not getting it?
Well, if there's been a failure to deduct, then you don't get the credit system.
But in what sense is what Regulation 9 providing for the recovery from the subcontractor?
Well, it's not directly in any sense, I don't think.
No.
Because the subcontractor has received a gross payment, and they must account for the tax on that gross payment in the ordinary way.
Yes, but that's not by virtue of Regulation 9.
No, not by virtue. That's just by virtue of the ordinary taxation of...
I draw attention to it in case it has any significance, the connection with Bahrain's reminded me of that. But there it is. You can't suggest any way in which that's a correct title, but you don't say any insignificance in its incorrectness.
No, my lord.
Well, again, Mr. Simpson may be able to help us on that.
As I said, my submission is Section 71. My learned friend, I think, leans towards Section 73, which is...
That's a supplementary.
Yeah. I'm not sure anything turns on the difference between the two.
Thank you.
The second point was the set-off. And my lady's observation that these aren't immediately the corporation tax or income tax liabilities. If we look, please, at Section 62 on page 12, which is the VIRES for these regulations, and in subsection 3 on page 12, if the subcontractor is a company, a sum deducted is treated in accordance with regulations paid on account of relevant liabilities. If we go down, please, to subsection 4, relevant liabilities of subcontractor or any liabilities arising before or after deduction to make payments with respect to an obligation as an employer or contractor. And the point I'll make in a moment is that this is primarily about tax on labour. It's not actually directly targeting you failing to pay your corporation tax, which may be a small proportion of the payment made. It's primarily about tax on labour, and then residuary tax on profit. Because you can imagine, if I pay 100 to a contractor in respect of labour, because you exclude materials costs, and they pay 90 to their worker to perform the contract, their corporation tax profit will be the 10, and tax on that will be 2. The bigger problem there is the 90. That's what they want tax on, because that's what might go missing. So it makes sense that it's focusing on the labour in the first place. And then you can see in C, subsection 3, paragraph C, if the amount is more than sufficient to discharge relevant liabilities, the excess is treated in accordance with regulations of the incorporation tax. So if there's enough left over, then it does discharge corporation tax.
It struck me there's also a sort of timing point here, because the liabilities that arise most immediately are the liabilities to account for PAYE,
Yes.
insurance and CIS deductions, whereas of course in principle the tax on profits is delayed, or at least it
Yes.
was when the regulations were introduced.
Yes, it depends on.
So the crediting mechanism, which is what we're looking at the moment, because we're in a hypothesis here where there is a deduction.
Yes.
The crediting mechanism broadly goes for most immediate bills.
The ones in respect of labour, yes, and that's followed through, as we saw yesterday, in Regulation 56. So if we could turn up tab 2, please, page 46. So this is for companies. In paragraph 2, the waterfall is first, you can see primary class 1 contributions respective employees. So this is targeting labour, then secondary class 1, and then various other things to do with employment. And then F, last in discharge of any liability of the qualifying subcontractor to account for sums deducted by it under section 61.
What's the rationale for treating companies differently from non-companies like partnerships? So traders who also subcontract.
Well, they have similar obligations, but in respect of income tax.
But section 62 says that it's to be treated as income tax in relation to profits. Whereas 62.3 makes a completely different provision for companies.
Sorry, but where's my lord reading from?
62.2,
Yes.
section 62.2. If the subcontractor is not a company,
Yes.
the sums to be treated as income tax in respect of profits. If the subcontractor is a company, then it's to be treated as paid on account of relevant liabilities. But a non-company could have such liabilities.
They could have. They could have.
So why is there an explanation for why a non-corporate subcontractor is treated differently?
I would have to give that further thought. My instinctive answer is it's more likely, well, in fact, it's necessary that the company will have others doing the work for it. So we'll either have employees or subcontractors, whereas a subcontractor who's within the scope of income tax may well just be a bricklayer, who's not an employee, in which case, and that's what it's targeting is your income tax, whether it's employment or trading on that labour supply. So it goes directly for what may well be the tax on the labour one. The point I was just finishing off in Regulation 56 is you can see the waterfall ends up with the subcontractor's own liabilities to make deductions under section 61. And then in paragraph 3, you see the reference to, sorry, that's the repayment, but then in paragraph 6, if it appears that there is an outstanding liability in respect of corporation tax due for an accounting period ending before the relevant payment is made, then you can set it off against that. I think the point I was making there is simply that the waterfall makes sense as part of a scheme targeting tax on labour.
makes, I see that. It makes somewhat less sense to me that when you get to Regulation 9 and Condition B, the focus is on a very different thing.
Yes.
The focus is on and only on tax on the profit. I'm not, it's an observation you may not have an explanation for, but there is a very striking difference in focus.
Yes. Well, there is. I understand my lady's point. I'm not in a position to take that further at the moment.
List piling up for Mr. Simpson. Simpson, we don't expect you to have instant answers to all these, but or maybe not answers at all. But it will help, obviously, if with the benefit of those behind you who represent those who made these regulations in the first place and who operate them, you may be able to help on. You can give us a good overall picture of how these apparent anomalies are not really anomalies at all. Best of luck to you.
Third, the board asked about the first year tribunal documents. I've handed up a stapled pack of sample documents relating to Beech. They contain in the first 2 pages on notice of appeal.
So sorry, forgive me, I just missed the beginning of that. What was this?
Third point is the FTT documents the court asked for yesterday, and I've handed up a sample pack from Beech. The first 2 pages are the grounds of appeal.
You say you've handed it up. Oh, sorry, it's got hidden under mine. Yep, thank you.
The grounds of appeal don't initially refer to Regulation 9, despite the prior correspondence.
So where does the grounds of appeal appear?
First 2 pages, my lord, and on the second page you can see, well, at the bottom of the first page it says appeal details, grounds of appeal.
Yes, I see.
It talks about quantification. Nevertheless, the point about Regulation 9 is added by way of further and better particulars, and that's the second document. That's just 2 pages in paragraph 7.
Yeah.
We then have HMRC statement of case. That's the third document.
Hang on, sorry, I'm being slow. Yes, I see. Yep.
And just to show you the points at issue at paragraph 40, whether HMRC have applied the correct test under Regulation 9, and also quantum, and then HMRC make the argument.
So whether they've applied the correct test under Regulation 9, so HMRC are taking the approach that Regulation 9 is engaged.
Well, no, we'll see later. They then take the objection towards Regulation 13, so how could we possibly have accepted? But you see at 42.2, burden of proof shifts to us to demonstrate that the Regulation 9 applies. HMRC ought to have directed. 76 on page 13 of the statement of case, we deal with Regulation 9. There's an initial observation that we didn't mention it originally, although it is in our further and better particulars. And you see the essence of HMRC's case at 78. HMRC contended the appellant's failure to make claims under Regulations 9.3 or 4 put forward any grounds or evidence in relation to Condition A means that the appellant had failed to satisfy the respective officers that the condition was met. Accordingly, they contended the Regulation 13 determinations were validly issued.
Do we need the first sentence of 79 as well?
Yes. They go on to say, well, in any event, we're not satisfied that you met the Condition A point. In procedural terms, it's not got very far. I've included at the end the most recent application for a stay, which narrates some of the history, but there's nothing in there I wish to draw your attention to other than to say, well, since the statement of case, not really much has happened because of these proceedings.
Yeah.
The fourth point, taking up from yesterday, was my Lord's question early on as to whether, in order for a Regulation 9 direction to be issued after a Regulation 13, is it necessary for the Regulation 9 conditions to have been satisfied at the time the Regulation 13 was issued? I believe that was my Lord's question earlier on yesterday. Given further thought to that, I think there's 3 points I would wish to add to what I said yesterday. The first point is that it's inherent, barring bad faith, that the statutory conditions will not be satisfied at the time the Regulation 13 is issued. Because both of them depend upon HMRC being satisfied of something. So the condition is not, you did take reasonable care, but the HMRC is satisfied with that. The condition is not, taxes have been paid, but the HMRC is satisfied with that. And the importance of that in relation to whether a statutory condition is met and whether a power is available is demonstrated by the OWD case, which is in our authorities bundle. Behind tab 12, please. This concerned HMRC refusing to register a person on the basis that HMRC were not satisfied they were fit and proper. We can see the statutory test in paragraph 12, subsection 2 of section 88C. Tab 12, page 410, paragraph 12, setting out the legislation that the Supreme Court was considering. It says, in subsection 2, the commissioners may approve a person under this section to carry on a controlled activity only if they are satisfied the person is fit and proper. At 38, the court accepts HMRC's argument that if HMRC are not satisfied that a person is fit and proper, they have no power to register them. So just below B, on the facts of these appeals, HMRC had nevertheless concluded that the wholesalers were not fit and proper. I would accept their argument that in those circumstances there is no power to grant temporary approval pending appeal. And just above D, indented slightly, section 88C operates through the medium of HMRC being satisfied the person is fit and proper. So the impact upon the person of the business of the refusal is not material to that evaluation. Similarly, paragraph 46. Between B and C, in the middle of the line, by subsection 2, the commissioners may only give the required approval if they are satisfied that the person is a fit and proper person to carry on the activity. So whereas here they are not so satisfied, they may not give approval. And without approval, the person may not carry on the controlled activity. Transposing that reasoning to Regulation 9, HMRC may only give, and only have power to give, a direction under Regulation 9 where they are so satisfied. And so, as I said, it's inherent that barring bad faith, HMRC will not be so satisfied at the time the Regulation 13 is issued, so it necessarily follows that the conditions will have to be met later. The second point in relation to this question is that the question of interpretation of Regulation 13.3 is, in my submission, binary. either Regulation 13.3 does preclude a Regulation 9 direction, whilst a Regulation 13 determination is extant, or it does not. There is no basis in my submission for concluding that Regulation 13.3 permits some types of Regulation 9 direction after a Regulation 13 determination, but not others. So, in other words, you can't say that, well, Regulation 13.3 permits a Regulation 9 direction if the underlying conditions in Regulation 9 were met at the time, but not otherwise, because there's no basis in Regulation 13.3 for that distinction. And so you have that binary question: either it does prohibit Regulation 9 5 directions afterwards, or it doesn't. And if it doesn't, the conditions for issuing a Regulation 9 direction are found exclusively within Regulation 9. Regulation 9 does not refer to Regulation 13, and it does not ask whether the conditions A and or B were satisfied at the time the Regulation 13 was issued.
Well, condition A, the time that HMRC must look at in order to decide whether they are satisfied that condition A applies must be the time when the contractor made the gross payment to the subcontractor, mustn't it?
And also the time thereafter when they should have paid over to HMRC. Yeah, so condition A is concerned with the contemporaneous situation. But the point I'm making is that in applying the conditions in Regulation 9, it doesn't identify the point in time at which either condition A or B must be satisfied. My Lord's point is, well, it's inherent in condition A that it will be concerned with the facts at the time. I agree with that. But my point is that condition B is not so concerned. And in fact, typically, the condition B condition will be satisfied sometime later, based on whenever you have to submit your tax returns and pay your tax. And so my point is simply that Regulation 9 doesn't refer to Regulation 13. It stands on its own terms. That the only time you need to assess whether those conditions are met, albeit for condition A with looking backwards, is the time when the decision under Regulation 9 falls to be made. So when HMRC had taken a decision, are we satisfied that condition A is met? Let's look at the facts. And then if HMRC are looking at condition B, are we satisfied? And they look at it at that time. And there's no reference to, well, don't look at it at that time, look at it when the earlier Regulation 13 determination was made. My point is there's no basis for looking at it at some earlier time. My third point on this is purpose. The substantive requirements of condition A, as I've just submitted, my Lord observed, will either be satisfied or not around the time of the contractor payment. The substantive requirements of condition B will be satisfied sometime later. The clear purpose of condition B is that HMRC shouldn't collect the contractor if the subcontractor has paid the amount in condition B. The force of that condition being met does not vary based on when it was satisfied. So condition B is saying, well, we think this is a sufficient reason to not implement or not collect on a regulation 13 determination. The force of that point does not vary based on whether the tax was paid and accounted for before or after the regulation 13. As long as it's satisfied at the time when HMRC are considering condition B, there's no reason why you shouldn't get the benefit of condition B being satisfied. As long as, of course, it's prior to the regulation 13 becoming final.
Yes, I mean the revenue, as is apparent from the regulations and also the absence of a right of appeal, the revenue have a clear discretion in relation to condition B. There's the substantive condition which you've been focusing on, but there's a further discretion. And
Yes.
Mr. Simpson may have something to say about that. In other words, it's not sufficient to get within condition B that the tax has been paid. There could be other factors that mean it's not appropriate to pay revenue tax as its discretion. And it's part of that. That was actually behind my question about the different focus of the tax. You know, the fact that condition B is looking at tax on profits is not looking at taxes on labour.
Yes, yes. My lady maybe is positing, well, what if you paid all your tax on profits but not your tax on labour?
Well, that sort of thing. I don't think that's for this court or
Not for
for
this
decision
hearing,
because
yes.
we're here on a
Yeah.
we're looking at the construction. But
Yes.
I wouldn't want to lose sight of that.
No, I understand my lady's point. I understand it. But in terms of the question being, well, do you have to have paid your tax on profits prior to or at the time of the regulation 13 in order to satisfy condition B? The submission I'm making now is no, you don't, for the three reasons I've just given. The further point my lady makes, well, there's still a discretion even if you do satisfy the underlying point, and that may raise issues if, for example, you haven't paid your tax on labour. I understand that. It's not for today. Because we haven't got that far in the process. HMRC have just
Indeed, but it's possibly relevant to construction, to the argument.
potentially, my lady. Those are my points from yesterday, and now I need to finish off my points from my supplemental skeleton. I finished off yesterday by explaining what in my submission amounts to a restriction on the right of access to justice. The key point being that HMRC can take away the jurisdictional power of the tribunal to hear, decide, and direct under a Regulation 9 refusal appeal, simply by issuing a Regulation 13 determination. The High Court accepted, this is paragraph 38, that this situation would be open to abuse by HMRC. My submission, well, that ought to be a good indication that if we could find an alternative interpretation that didn't allow abuse, that should be adopted. But nevertheless, dealing with the High Court's reasoning head on, it was accompanied, in fact, it relied heavily on its belief that HMRC's conduct in relation to issuing then withdrawing a Regulation 13 determination was regulated by public law principles. And so, for example, in relation to if HMRC did, in bad faith, issue a Regulation 13 solely to forestall a Regulation 9 appeal, then the belief of the High Court was, well, that will be dealt with through judicial review. My submission is there's two reasons why that isn't an adequate answer to the problem identified. The first is that the suggestion that in order to access a right of statutory appeal, you have to go through the alternative mechanism, judicially reviewing a Regulation 13 determination, and getting that set aside, and then you can go forward with your statutory appeal, doesn't maintain the right of access to the courts. It still represents a very significant barrier to exercising the right of access. as I say, at 41, so a right of appeal to the first tier tribunal has been granted. That is deliberately a less formal process. There's no fee to commence the tribunal process. There's usually no risk of adverse costs, and it's an overall more informal process. And that enables taxpayers to exercise their rights in relation to tax matters in a comparatively low-value case, which, although this is a high-value case, I'm sure there's plenty of these sorts of instances which would relate to much lower values. And I draw an analogy with what was said in Unison about the employment tribunal being an easily accessible, speedy, and informal, and inexpensive procedure. Judicial review, in contrast, as this court will know, and as these proceedings demonstrate, is a formal and expensive process. You have to get through a permission stage, and the loser pays the winner's costs. And in my submission, and again, drawing the analogy with Unison, where they held that a £390 fee would effectively, or could effectively, prevent access to justice. There's no doubt, or there should be no doubt in my submission, they're having to mount a successful judicial review to get rid of the Regulation 13, simply in order to pursue the Regulation 9 right of statutory appeal, represents, as I said, a significant barrier or impediment to the right of access to the tribunal. The second answer is that, and the second reason why public law principles are not an adequate answer, is that the High Court's failed to consider the full breadth of the situations in which you may have a Regulation 13 determination whilst a Regulation 9 appeal is either forthcoming or already in existence. And so while the High Court seems to be concerned with cases of abuse where HMRC wrongly tried to derail Regulation 9, there's a much more obvious and important situation in which HMRC would have to issue the Regulation 13 whilst the Regulation 9 was extant, which is where they're up against a time limit. And Mr. Simpson accepts at the end of his supplemental skeleton that yes, we would have to. If we were up against the time limit, we'd have no choice. To protect the revenue, we would have to issue the Regulation 13 determination. And it's an arbitrary matter when, within the 4-year ordinary time limits, HMRC find out the facts and therefore consider the Regulation 13. And it's an arbitrary matter as to whether any appeal against a refusal of Regulation 9 direction is concluded within the 4-year period. One can reasonably expect that in a significant number of cases it may not be. But in terms of the principle, you have a situation where HMRC will have to protect the revenue, issue a Regulation 13, even though there is a Regulation 9 appeal that is ongoing. And you couldn't challenge that Regulation 13 determination on, as far as I can see, any successful grounds, because it's not made for an improper purpose. In fact, it's made for the perfectly proper purpose of protecting the revenue. And that's the point I make at paragraph 51 of my supplemental skeleton. You end up in a situation where HMRC have issued a perfectly valid Regulation 13 for a perfectly proper reason. Therefore, you can't judicially review it. There's nothing wrong with it. But that gives rise to the fact that now you've derailed and rendered defunct the Regulation 9 appeal. And that's as I said, in my skeleton, a significant problem with the High Court's interpretation, because it gives rise to impossible situations. Either HMRC have to not issue the Regulation 13 to allow the Regulation 9 appeal to run its course, in which case they risk allowing the tax to go out of time, the amount to go out of time, or they have to issue the Regulation 13 determination to protect the revenue and thereby render the Regulation 9 appeal defunct. In my submission, the court should, if at all possible, steer clear of an interpretation that leads to that sort of impossible choice. if there's an interpretation that allows HMRC to protect the revenue by issuing a Regulation 13 without thereby derailing a statutory appeal that the right to which is granted in clear terms, it's obvious in my submission that that should be accepted, and that's my interpretation. My sixth point, paragraph 54 of my supplemental skeleton, is a point I've already made, so I'll take it briefly, which is that the supposed power of withdrawal, which the High Court considered so important, in fact it seemed to be a necessary part of how it saw the scheme working, whereby the Regulation 13 could be put in place but then withdrawn if HMRC later became satisfied. That power doesn't exist. I've taken you already to section 30A, subsection 4, I don't need to take you to that again. I've referred in my skeleton argument to the Court of Appeal decision in Bayliss and Gregory, which considered exactly the same wording, albeit in an earlier form, and concluded that HMRC didn't have power to vacate an assessment. And I don't understand Mr. Simpson now to disagree with that. Instead, he says, well, maybe we can't withdraw it, but we can exercise a discretion not to collect on it. But that's as I said yesterday, we've moved a significant way away from the High Court now, because the key part of its overall structure doesn't exist. And what that means, as I say at 59, is the only express basis, and therefore the only basis for altering or withdrawing a Regulation 13 determination is in response to a valid appeal against the Regulation 13 determination. That right of appeal I showed you yesterday is in section 31, and it requires grounds of appeal. This leads into my seventh point, which in my submission is that there must be a right of appeal against a Regulation 13 determination based on Regulation 9.
Well, you're saying effectively you can appeal the Regulation 13 saying either Regulation 9 direction has been made, in which case it shouldn't have been issued at all, or one ought to be or ought to have been made.
Or will be made, yes.
Okay.
Because the problem with the ought to be made formulation, which I think Mr. Simpson refers to, relies on in his skeleton, is does that then involve the first tier tribunal on the Regulation 13 appeal, considering whether conditions A and B were met such that HMRC ought to?
Well, they effectively can have jurisdiction under condition A, but the problem is they can't under condition B.
Well, the jurisdiction in condition A should logically come from Regulation 9 and the refusal appeal.
Indeed.
So I agree that there's no, they have jurisdiction in relation to that matter, but not on this appeal, or at least not obviously on this appeal.
Okay. Well, that assumes that you
Yes.
can't extend your appeal to cover.
Well, possibly, but then, as my lady just pointed out, if you accept that condition A can be considered, you also have to accept that condition B can be considered. And that's as I say, the real problem with that interpretation.
Presumably in this case, although the taxpayer has referred to condition 9.3,
Yes.
there hasn't actually been the process of issuing a refusal
No.
notice, which is
No.
the point we're making, which would formally engage the right of appeal.
Yes. So, well, based on my submission, if this court were to agree that HMRC can issue Regulation 9 directions after Regulation 13, then the expectation, as I see it, would be that HMRC would then have to formally take a decision on condition A, formally notify their decision on condition B, and then get the refusal appeal if we don't accept their decision on condition A, and potentially judicial review if we don't accept their decision on condition B. If it's negative, it could be positive. I don't want to assume things against myself, but then if the refusal appeal is successful and the tribunal directs HMRC to issue the Regulation 9, then you have your basis for allowing the appeal against the Regulation 13, because now you have a Regulation 9 in relation to that amount. And similarly, if either HMRC accept the condition B is met and issue the direction or on judicial review, it leads to that same end result, then you also have a clear basis then for allowing the Regulation 13 appeal, which doesn't involve directly considering condition A and B in that appeal, but instead taking notice of the existence of Regulation 9 directions.
Yes, once you've got your answer on condition 9, the outcome of the Regulation 13 appeal may well be obvious.
Yes.
Well, there
Well,
might, there might be other things in dispute.
Yes.
But,
Yes.
if that's the only matter, then the simple arithmetical
Yes.
outcome.
Yes. But this is simply the result of having two parallel regimes. Instead of having a single sort of sequential regime whereby conditions are considered as part of the Regulation 13 process, you've got two parallel regimes and they have to interact.
In practice, if it were a condition A case, the condition A appeal and the Reg 13 appeal would proceed in tandem. Is that how it works?
That's what I've suggested in my skeleton, yes. And in relation to condition B, well, you'd have to stay it and await the outcome of the judicial review, if there was a judicial review, in the same way that we've had to stay in this case.
And in a condition B case, the outcome of the judicial review, well, it would rather depend, wouldn't it, what the ground of challenge was.
Yes.
But if on certain grounds of challenge, the outcome of the judicial review would, on your model, determine the Regulation 13 appeal.
As my lady said, it would logically lead to the conclusion of, but it wouldn't be the decision, but it would lead to the decision. Right.
Yes.
And the parties you can have Section 54 agreements in relation to extent
Yes.
FTT.
Sorry, I was about 2 steps behind my lady, but that's unsurprising.
But I was taking this point in 2 stages because, and I think that, well, I submit that may be useful. Simply to say there must be some way you can rely on Regulation 9 to appeal a Regulation 13, and then to deal separately with the what form would that reliance take point. We've already just been through the what form the reliance would take, but nevertheless, I think it is useful to take that first step and just understand in my submission why it's necessary. And that's what I set out in paragraph 60 and 61. Because if it were otherwise, such that you couldn't rely on Regulation 9 to appeal a Regulation 13 determination, a taxpayer receiving a Regulation 13 determination who accepted that they ought to have deducted an amount, and whose only hope was conditions A or B, and they may well have a condition A appeal extant at that time, would have no basis for appealing the Regulation 13 determination. And if you can't appeal it, it becomes final. As we've seen, HMRC can't just withdraw it. They can the only way of displacing the Regulation 13 once issued is through the formal appeals process, which I've shown you. That's the only express provision in the Taxes Act. And so if you can't appeal it, in some way relying on the Regulation 9 points, then you're left with a final Regulation 13 determination that can't be withdrawn. And so, given that there must be some way of relying on Regulation 9, and assuming, I think it's common ground, you can't expect a taxpayer to make an appeal against the Regulation 13 on spurious or false grounds just to keep it open, so there has to be some legitimate ground. Then the question becomes, what is that legitimate ground? And that's the point that is just being raised by the court, and that's the one I deal with at 65, which is that if, as my lady said, if a Regulation 9 has already been issued, such that the Regulation 13 should itself never have been issued, that's not really a problem. You would just say, well, we appeal the Regulation 13 on the basis of the pre-existing Regulation 9. That's easy. In the converse case, as I say, 67, if there isn't already a Regulation 9 direction, then the appeal would have to be on the basis that one will be made. And as I say, then the first tier tribunal could logically consider any appeal against a Regulation 9 refusal at the same time as the Regulation 13, and the outcome of the Regulation 9 would inform the outcome of the Regulation 13. And that interpretation, or that outcome, the fact that you can rely on Regulation 9 to appeal a Regulation 13, depends upon the first-tier tribunal being able to direct HMRC to issue a Regulation 9 direction, even though a Regulation 13 is currently extant. Because the hypothesis is, for example, HMRC have issued a Regulation 9 refusal, that's been appealed, the appeal is ongoing. Let's say for time limits reasons, HMRC have to issue the Regulation 13 determination. The taxpayer then has to rely on Regulation 9 to appeal the Regulation 13. They say, well, we believe a Regulation 9 will be made, here's our appeal. You then have to consider the Regulation 9 first, because the Regulation 9 direction, if made, is the reason why the Regulation 13 appeal will ultimately succeed. So the Regulation 9 direction for the tribunal has to come before allowing the appeal against the Regulation 13.
I think for the reasons already discussed, your point in 68 about the FTT being able to direct HMRC to issue Rule 9 direction, I understand that in the context of Condition A, but I can't immediately see the FTT would have jurisdiction to direct the issue of a Rule 9 direction in the context of Condition B. Surely that has to go through the judicial review.
My lady's correct, yes. I'm simply taking the easier example,
yes,
which is the Condition A, where you can appeal to the tribunal. My lady is entirely right. If the answer to the Regulation 13 was, well, we accept that we should have deducted tax, but we think Condition B is satisfied and you, HMRC, haven't taken a proper decision on that, here's our judicial review, then the answer would be the Regulation 13 has to be stayed pending the outcome of.
Yeah, okay, I just wanted to clarify.
Absolutely, my lady. And as I said previously, the advantage of this interpretation is it doesn't involve the first-tier tribunal considering the substantive Regulation 9 conditions on the Regulation 13 appeal. It also does not depend on having to find in some way that HMRC were under an obligation to issue the Regulation 9 at the time the Regulation 13 was issued, which is how I understand my learned friend may be putting this point in saying, well, if we were under an obligation to issue the Regulation 9 when we issued the Regulation 13, that takes precedence over the Regulation 13, I think is what is said. I've already explained fourth of my preliminary points today, that HMRC can't be under an obligation to issue a Regulation 9 unless they are so satisfied. So as long as they're not satisfied, they don't have an obligation to issue Regulation 9. In fact, they don't have a power to, because the gateway for the power is you are so satisfied. So I don't see how it can be said that HMRC were under an obligation to issue a Regulation 9 simply because the underlying point is argued to have been satisfied. And my lady's point, that is the submission. It's also not apparent how that would work in practical terms. The suggestion that, well, it's the obligation, even if there was an obligation, it's the obligation to have issued a Regulation 9 that is crucial. Because you can imagine a case where HMRC refuse a Regulation 9 direction under Condition A because they're not so satisfied. There's then 30 days to appeal. That refusal. In that period, HMRC issued the Regulation 13 determination. And the question I ask rhetorically is, how can it be said that in that 30-day period, HMRC are under an obligation to issue a Regulation 9? So, assuming in good faith they have decided they weren't so satisfied, nevertheless there's an appeal, there's a potential of an appeal, and HMRC have to say, well, in that period we were under an obligation even though we weren't so satisfied. But What if the appeal never materializes? Do you then say, well, retrospectively, you weren't under an obligation? I mean, I don't see how it works, because the Regulation 13 is issued within the 30-day appeal window in my example. HMRC are asking the question, well, were we under an obligation at the time to issue Regulation 9? And I don't see how you can sensibly answer that question, particularly given the taxpayer may decide not to appeal the Condition A refusal. In which case, does that retrospectively mean there wasn't an obligation, whereas if they had appealed, there was? It just leads to all sorts of conundrums. So not only is there no obligation because the condition isn't satisfied, because HMRC weren't so satisfied, but it also leads to practical problems. That takes me finally to my response to the High Court's observation that my interpretation is artificial or subversive. And my response is respectfully, well, I don't think it is, I don't submit it is, but it's certainly no more artificial and subversive than the approach the High Court's interpretation leads to. And the point the High Court seemed to find strange was the idea that a Regulation 9 could be issued in respect of an amount, but not immediately apply to that amount, but the very existence of the Regulation 9 would then drive a chain of events that would lead the withdrawal, there was a power withdrawal of the Regulation 13, and thereby allow the Regulation 9 to apply. Well, I mean, in my submission, as I've already submitted, a Regulation 9 direction may well lead to a Regulation 13 determination being allowed, but in the absence of an appeal against the Regulation 13 determination, the Regulation 13 is final. And that's just simply the way it works. There's nothing artificial about that. It's just how these two parallel regimes, which haven't been sequentially organized, interact with each other. I'm sure sitting here today we could come up with a better scheme that was more logical and sequential, but we're dealing with what we've got. But then you have to consider the alternative, because the High Court's interpretation is no better, in my submission, much worse. Because on that view, so the problem with my views, according to the High Court, is that the existence of the Regulation 9 will lead to the withdrawal of the Regulation 13 and allow the Regulation 9. The High Court's interpretation is that an entitlement to a Regulation 9, if established, can lead to HMRC being required to withdraw an otherwise perfectly valid Regulation 13 determination in order to allow HMRC to issue the Regulation 9 direction that the Regulation 13 was previously precluding, and therefore allow the Regulation 9 concept overall to succeed. I don't see how that's any better or any less subversive, if subversive is the right word, than my interpretation. It's simply attaching the weight to the entitlement to the Regulation 9 and saying, well, that can drive the withdrawal of the Regulation 13, which then allows the Regulation 9, which then allows the taxpayer to succeed. That's no different in my submission, worse than just simply acknowledging the Regulation 9 can be made after and is a ground on which the Regulation 13 appeal can be allowed. And it's worth considering in practical terms how the High Court's apparent concept would work, because the taxpayer has to ask HMRC for a Regulation 9 determination at a time when HMRC have no power to issue one.
Well, on HMRC's case, not only do they have no power to issue one, they have no power to consider the taxpayer's request.
Yes, exactly. Say that
That's
they will
what
consider.
The decision letter says. It says we can't consider it.
That's what the decision letter says. But then my learned friend says in his supplemental skeleton, but don't worry, we will consider Condition B before we collect on it. So it'll be part of our care and management power. So, as I said yesterday, you seem to get to the same end point, but via a very circuitous route. But in the High Court's world, you have to ask HMRC for a direction they're not allowed to give you. They have no power to give you. Then HMRC have to consider whether if they did have the power, they would have given you a Regulation 9. despite not having the power to do so. And if HMRC conclude that, well, if we had had the power, we would have exercised it in your favour, therefore we will give ourselves the power by withdrawing the Regulation 13. Magically, we now have the power, and here's your Regulation 9. I mean, that seems, to my mind, far more artificial than simply accepting a Regulation 9 can be issued after Regulation 13 and allowing the two to play out in the way I've described, which is that until the Regulation 13 is final, then you can rely on the Regulation 9. I think I've already made the point of paragraph 73, which is that the High Court was wrong to think that, in my interpretation, the Regulation 9 always has priority whenever made. I've explained that no, once the Regulation 13 is final, then it can't be withdrawn and the Regulation 13 will prevail. So it comes down to whether there's a live appeal against the Regulation 13. If I may just turn my back for one moment. Unless I can be of further assistance, those are the submissions.
Thank you very much, Mr. Smith. Yes, Mr. Simpson.
Thank you, Lord. Obviously, I here on behalf of the commissioners to oppose this appeal. I will first try to fix this lectern so that it doesn't fall over the matter every time I touch it. In any event, I adopt my scouting arguments, subject to one point I'll come back to in a minute. I propose to divide my submissions into 4 chapters. First will be on legislative context in which this issue arises. The second will be to highlight just 1 or 2 of the facts that in my submission are of importance. The third will be to respond to the preliminary points that my learned friend made yesterday.
Sorry, to the what point?
To the preliminary points, the points my learned friend described as having arisen out of the Commissioner's supplementary scouting argument.
Right.
And finally, as my learned friend has done, I will give my response to his own revised or replacement scouting argument.
Yes.
So the first point, just to emphasize, my learned friend has said a number of points that he understands that it is now conceded or common ground that HMRC do not have a power to withdraw a Regulation 13 determination. Now, I wish to be clear, I'm not making that concession.
So this is part of your first heading, legislative context.
Well, this is the point at which I'm departing from my. I'm just making clear about my scouting arguments. What I'm arguing. Sorry.
Okay, not conceding that no power of withdrawal.
But my instructions are, for the purpose of this appeal, in terms of collection management powers, to rely only on the proposition that it is within the collection management powers of HMRC not to collect money that would be due under a Regulation 13 determination.
Sorry, you're not conceding that there's no power to withdraw generally, but
yes,
for the purposes of this appeal, you're confining
Yes, I'm confining my submission to the proposition that it is within the Commissioner's collection and management powers not to collect an amount that would be due under Regulation 13 determination. So I just want to make that clear before I embark upon my 4 chapters.
Yes, well, we obviously can't make you argue a point you don't want to argue. It leaves us in a slightly unsatisfactory position for other cases. But there we are.
Indeed, my Lord. But those are my instructions.
In practice, you are conceding, but only for the purpose of this appeal.
Well, perhaps
I don't see a distinction between not. Well, all right.
Yes.
Your position can be recorded as not wishing for the purpose of this appeal to contradict the submission that there is no power of withdrawal.
Yes, my Lord. Yes, my Lord.
Well.
So what's the taxpayer supposed to tell his auditors? We've had this Regulation 13 determination. We've got a liability. What do we do with it in the accounts? How do we know that HMRC are not going to collect on this?
Because as I think it was Your Lordship, perhaps Your Lordship and the Chair mentioned yesterday, there would inevitably be some communication from HMRC stating that position.
Why?
Sorry?
Why?
Well, because having exercised our power to decide not to collect a particular debt, yes, the commissioners couldn't leave the taxpayer, not the taxpayer, the addressee of a Regulation 13 determination.
Well, couldn't as a matter of fairness. I mean, the whole thing is rather odd. Are you effectively, again, I'm not going to pin you down to an undertaking in the formal sense, but are you telling us that HMRC recognise an obligation in circumstances where they decide not to collect, to write a letter of a binding character saying we are not going to collect this amount?
Yes, well, that's my understanding, and certainly, yes, that's.
So we write off the debt, and it doesn't have to feature in the company's accounts.
That would essentially be the position, my Lord.
I understand that. So I postulated yesterday that the tax might have been paid. There are various reasons why the tax might already have been paid. This situation may arise not simply where the revenue haven't collected it yet, but may have arisen where the tax has been paid for one reason or another. Maybe an unsuccessful postponement application, whatever it is. Do you have instructions as to that?
I don't have the express instructions as to that, but I can get them. I will see what I can do over the.
Well, the logic of your position has got to be that they would, in those circumstances, be repaid.
Yes,
there are. And again, you would repay it simply under your general management and collection powers.
Well, that would indeed be the logic of it, but let me see if I can obtain specific instructions on that point.
I have to say for myself, on just going back to the power to withdraw, it relied on very heavily by the High Court. We've heard submissions that there is no such right. The point is engaged directly in the case. And the court's being asked to express, certainly being asked by the appellants to reach a view on that point.
Yes, Milady, I appreciate the difficulty, but all I can say is those are my instructions.
Can I just go back to this question, follow up from my lady's question? She asked you what would happen if the tax had already been paid before HMRC decides not to collect. And you said it would be repaid under general collection and management powers, I think.
Well, I said that was certainly the logic of the position.
Right. Because in your original skeleton argument, you disputed the idea that HMRC could keep the money and your response to the assertion in the original skeleton that that's what would happen would be that it would be used to pay for public services and other costs of the state, i.e. it wouldn't be returned to the taxpayer. But you're not persisting in that position, as I understand it.
Well, the point being made there, which, as I understand, is no longer being made by the appellants, was that any interpretation that allowed a Regulation 13 determination to subsist where there were grounds for relief under Regulation 9 led to a windfall, that's how it was put, for HMRC, because HMRC would receive money under the Regulation 13 determination, but would not have to apply it to any tax liabilities of the subcontractor. So that was somehow a windfall for HMRC.
You say somehow as if it's a surprising proposition. It seems to me a common sense proposition.
But it's in my submission, the way this legislation works is it's not a windfall. That's simply the way the legislation works, and it's somewhat unrealistic to describe something as a windfall for HMRC as if HMRC are making some profit.
No, but this is it's not a profit in the sense, obviously, it's not going to spend the money on sweets, but
yes.
This is legislation, the specific purpose of which is to collect from A to discharge the liabilities of B. If it turns out that B has no liabilities, the basis on which A has paid is undermined. And most ordinary people would call that a windfall.
Well, anyway, that was the context.
I can't speak for most ordinary people. I'll settle for saying I would regard it as a windfall because the only legal basis on which it's been paid has been, the purpose for which it has been paid, I should say, does not arise, does not eventuate it.
No, but of course, in the context which we're talking about, one has to remember my submission and be quite clear about this. The starting point for any of this, any of the issues we're discussing in this appeal, is a failure by the contractor to comply with its primary statutory obligation to make a deduction from a payment. So the starting point for any of this is that the contractor has failed in its statutory obligation.
Well, I see a hard-nosed but legitimate argument that, well, tough, it may mean that you end up paying in circumstances where the primary purpose of the legislation isn't met. But that's your own fault because you didn't do what you were supposed to do. And you no doubt say, adding as a rhetorical point, and you were warned that this was the position and you still didn't do it. I see that, but it doesn't mean that you don't end up with a windfall in the sense I've defined.
Well,
it's a windfall, no doubt, as a result of an error by the taxpayer.
But the net effect is the revenue has collected more tax than Parliament has authorised.
No, my submission is that the payment due under the CIS scheme by the contractor to HMRC is not a tax. It's simply a payment that's due. It's nowhere described as tax due by the contractor, and that's vouched, for example, by the fact that Regulation 13 provides that a Regulation 13 determination is to be treated as if it were an assessment. In other words, it is not an assessment. It is not collecting tax. It's simply collecting a payment that is due in terms of our primary legislation envisages that the contractor has to pay HMRC an amount it was liable to deduct, whether it deducts it or not. It's perhaps not necessary for the court to decide whether it's a windfall or not. Simply, I've gotten this to try to explain the context of the particular point that was made in my original skeleton argument.
Well, there we are. I mean, but to come back from where where we got into all this, you have express instructions not to advance any submissions in answer to Mr. Firth's argument that there is no power of withdrawal for the reason he gives. You don't have express instructions not to say to submit that if a payment has already been made, the money would have to be repaid. But you say you will seek such instructions, and you acknowledge that's the logic of your position.
Yes. Yes, my lord.
Well, it's fruitless for us to say that we don't. I don't regard this as a very satisfactory stance for the revenue to be taking, but we are where we are.
Indeed, my lord. Indeed.
Nothing to stop us saying whatever your instructions are. We've only heard argument. We've only heard Mr. Firth's argument, and that satisfied us and decided as a matter of law that, I've forgotten now which section it is, means you don't have any power of withdrawal. You can't say, well, that's not going to bind in another case to say we might not want to argue it in another case. If you don't argue it now, maybe left with a result you don't like.
Well, my lord,
There we are.
yep, I'm afraid I can't take that any further at this point.
I haven't consulted my lady on this, but that's certainly what I think the risks of your position are, but
yes,
so be it.
Yes, my lord, yes. And yes, that message will of course be passed back. Now, turning then to Chapter 1, legislative context, as I mentioned, the basic point is that the contractor is obliged by primary legislation to make deductions. If we just have a look at one or two of the sections briefly. The first is Section 59, which is in tab 1 of the Authorities Bundle, Section 59 of Finance Act 2004. It's at page 5.
Yep.
So who can count as a contractor? Subsection 1A, any person carrying on a business which includes construction operations. If I can put that in one category. Then various other entities in B to FA, broadly speaking, public bodies. G is the Secretary of State, and then other public bodies in H to J, and so on. L, we note a person carrying on any business, a person's expenditure on construction within 12 months exceeds £3 million. Subsection 2 also applies that de minimis expenditure of £3 million in 12 months to everyone else except the first category is someone carrying on business, including construction operations, and G, the Secretary of State.
So, what is the point you're making from this?
So the point is that when it comes to access to justice, my learned friend draws a comparison with the Lewison case, and in particular, a fee of, I think it was £120 to lodge a claim in the Employment Tribunal. He says that if a fee of £120 is too much, then a fortiori the cost of lodging a claim for judicial review in the High Court must be such a deterrent to access justice that the point that one could take a judicial review doesn't assist the commissioners.
But if I've understood these provisions, the 3 million doesn't apply to anyone within 1A.
That's right.
So a small company, small builder who carries on his business in an incorporated fashion would fall within A potentially.
Yes, it may be a small business, but as a generality, of course, that
In
is.
fact, it's not even an incorporation. Anyone can carry on a business.
Yes, it involves construction operations. So
a builder sole trader who subcontracts to a plumber.
Yes, it would include that.
Where does that leave your point?
Well, the point is,
some people will be very rich or have high turnover, but not everyone.
No more, but as a generality, these provisions are focused on people who are actually whose business is construction, or otherwise people who are obviously have a degree of wherewithal.
There are lots of small businesses up and down the country who carry on construction operations. I mean, if I want work done on my house, I'm not going to employ one of the big developers to do it. I'm going to get a local builder to come and do it. Likely to be a company.
Yes, my point is simply that it's not as simple as saying £120 to make a claim in the employment tribunal is enough of a bar to access a justice that can't be allowed. Therefore, because the cost of making a judicial review application is more than that, it necessarily follows that...
it's not irrelevant, though, is it? That there will be, or at least maybe, a large number of corporate bodies, or indeed jobbing builders, who are caught within A. May not be quite as stark as the Unison case, but that's a question of degree.
Indeed, it's a question of degree, and it's not as simple as in my submission.
I don't think Mr. Firth was suggesting this was on all fours. He was looking at a question of principle, illustrated by Unison, because that was an authoritative statement of the principle.
Well, I may have misunderstood his argument in his replacement skeleton argument, so I'll move on in any event. Section 62 then, which is on page 12. The only particular point I want to note here is section 62 1b. So where a sum is deducted under section 61 from a payment made by a contractor, it's to be treated for the purpose of income tax or corporation tax as not diminishing the amount of the payment. So the subcontractor still has to make its income tax, or her its income tax or corporation tax return on the basis of the full amount that was received. And that...
so using the judge's basic example, the subcontractor's got to account for the 100, not the 70.
Yes, that's right. That's right. On the question of VIRES, I'm not sure anything turns on it. My friend said that the VIRES for Regulation 9 was Section 71. Which, sorry, is on page 29. Subsection 1, the commissioners must make regulations with respect to collection and recovery, whether by assessment or otherwise of sums required to be deducted. Of course, Regulation 9 involves the non-recovery of liability, so it may be that the VIRES is, in my submission, Section 73, which is on page 32. Section 73.1, the board may by regulations make such other provisions for giving effect to this chapter as they consider necessary expedient. in any event, I do note that both Regulation 9 and Regulation 13 are, of course, regulations made as part of a scheme when they were made, the board, I think.
Sorry, I didn't catch what you just said. They're part of a scheme and then you said something else.
In the regulations made by the board, the Board of Inland Revenue, as I think it was at the time the regulations were made. The board did not take the hard-nosed approach that my Lord and the Chair saw as one possible approach, anyway, and say simply, if you haven't made your proper deduction, you still have to pay us, and that's tough luck. Instead, the board conferred this these possibilities of relief. But obviously,
sorry, which possibilities of relief?
In Regulation 9.
In Regulation 9, I see.
Yes. And set down the conditions for them, set down one appeal right for Condition A, but not for Condition B. And then set out in Regulation 13, in my submission quite clearly, how the interrelationship between them, between a Regulation 9 direction and a Regulation 13 determination.
What is the logic for having a right of appeal in relation to Condition A but not Condition B?
Again, I haven't been able to find out why overnight, I'm afraid, but I would suppose that it is to do with taxpayer confidentiality. Having said that, in a circumstance such as the present case, where everyone's part of the same group, that doesn't apply. But in the generality of cases, one would expect a subcontractor to be an entirely separate taxpayer from the contractor who ought to have deducted the payment.
Well, if taxpayer confidentiality is the concern, how does judicial review operate in relation to Condition B? If, for instance, there is a factual dispute between HMRC and the contractor about whether the subcontractor has paid everything due, how's that going to work?
Well, if there's a factual dispute, then that must assume that the contractor has somehow obtained from the subcontractor information about the subcontractor's tax position.
Your subcontractor has told me I've paid everything.
Yes.
That's all I know. He's told me he's paid everything.
Yes.
And you, the revenue, say, well, we don't agree. Now, how's that going to be by judicial review?
If the contractor has enough evidence to show that all the tax has been paid, then inevitably HMRC must have either taken into account an irrelevant matter or left out of account a relevant matter. And the decision or the failure to grant a direction based on Condition B is liable to challenge on that basis. Essentially, in my submission, the absence of an appeal against failure to grant or not granting a Condition B direction is unlikely to deprive a contractor with sufficient knowledge of the facts of a remedy against that. The way the regulations work, the way they have simply been drafted, is to confer a right of appeal in relation to Condition A, but the decision, for whatever policy reason, is in Condition B, you have to go to judicial review. Again, I haven't been able to find out any more about the logic behind.
Surprised by that. I appreciate time is short, but this is litigation which has been going on for a long time. No one thought. Is there no one in the HMRC who understands the genesis and the thinking behind this? It's an important part of their policy. There must be someone in charge of the construction industry scheme who's given some thought to this. No?
Yes, although of course the regulations were 20 years ago now.
There's no corporate memory left.
So I'm not sure there is. Certainly none that's been able to
If
be
you've asked, you've asked.
found.
Surprising.
So that was what I wanted to say about the primary legislation, I think. Moving to the regulations, tab 2, briefly just a note in regulation 7, of course, at page 40. The regulation 7, paragraph 1, contractor must pay to HMRC all amounts he was liable to deduct. Whether or not they're actually deducted, that reflects as conferred by section 71.
What's the tax period?
The tax period, I'm not sure that's defined in this regulation. I think that's the tax year.
I think it's more often than that.
But
It's either monthly or quarterly, isn't it?
I've got the check. Regulation 2 says tax period means a tax quarter if regulation 8 applies, or a tax month in every other case.
So I didn't catch that, Mr. Firth.
Tax period means tax quarter if regulation 8 applies, or tax month in every other case.
So that's the frequency with which these payments are to be made. Then regulation 9 on page 41. Regulation 9, 3, condition A is that the contractor satisfies an officer of HMRC about reasonable care, good faith, and so on. Yes, there's no specific wording that a contractor has to make a request to HMRC, but plainly the contractor does have to do something positive. All three conditions, reasonable care, plus either error in good faith or genuine belief, involve information that only the contractor can have. It's not something HMRC is likely to find without the contractor putting it forward. So the contractor must do something positive, even if there's no wording requiring a request to be made, which of course there is in condition B.
Again, but I suspect the answer may be the same. Given what you have just said, one might have expected that condition A would likewise have an express provision equivalent to B under paragraph 4. The contractor asks for a section for paragraph 5 direction, but you don't have any explanation for why that's been omitted.
No, Malone. I suspect the point may be simply that the draftsman regarded it as inherent in the very idea.
I see. The point you make, you say, is actually a reason why it might not have been included, rather than a reason why it should be.
Yes.
Now, I sort of see that.
Yes, my lord.
Okay, thank you.
What the direction? What then may be on paragraph 5, an officer of HMRC may direct that the contractor is not liable to pay the excess to the commissioners. The excess, of course, being the amount that ought to have been deducted but wasn't. And then I do want to look.
So if suppose that condition A is satisfied.
Yes, Lord.
So HMRC have satisfied that there was reasonable care and there was a genuine belief that Section 61 didn't apply, whatever it is. What sort of grounds would arise under Regulation 9(5) when the officer is considering whether to direct non-liability? Because presumably he can still say, well, I've satisfied that condition A is satisfied, but I'm not going to make a direction. That would be within his discretion if there were a reason for it.
Well, my lord, as I said in the High Court, the wording of this is permissive.
Yes.
As opposed to obligatory. It is difficult to imagine circumstances in which the officer could refuse to make a direction if those were set out, because the conditions to be satisfied are set out in paragraphs 3 and 4, and I'm not sure that anything apart from that would simply be an irrelevant matter to be taken into account.
Well, let's say he did take something else into account. It's open to the taxpayer to appeal
Yes.
the refusal notice, and the grounds of appeal are those conditions. There isn't a reference to a further discretion.
Indeed.
So in other words, if the FTT decides that the conditions are met, well, agrees with, in this hypothetical example, agrees with the inspector that those conditions are met, then the appeal appears to succeed.
Yes. So it appears that
via that route, there's little scope for a discussion.
Yes. Well, I was just going to come to 8 and 9 and say that yes.
I mean, might be easier just to say this is one of those circumstances in which when may does in fact, on the proper construction of the statutory scheme, mean must, because it would be bizarre if the revenue could take into account matters which can't be taken into account on an appeal. So
yes, indeed.
No doubt perfect drafting would have said must or should, but may. Drafting isn't always perfect, and may does sometimes mean must.
Yes, indeed. So if one looks, as I was going to 8 and 9 in particular, the scheme of Regulation 9 indicates that may should be interpreted as must.
Well,
and
you need to do a lot of extra drafting because Regulation 9(5) is not specifically tied to either condition A or condition B. So you have to read it, and then you've got 6 as well, which deals with what happens if condition A is not met.
Yes.
And again, you've got the word may.
Reg 9 does say the sort of starting point is that condition A or B is met. So
yes.
Yeah.
Well, and condition A or B is met. Yes. And yeah. So of course in Reg 6, for example, then if condition A is not met, an officer may refuse to make a direction. If one is reading may as permissive rather than obligatory, that suggests that actually if condition A is not met, the officer still has power to make a direction.
Even then, the drafting is peculiar because, as my
Yes.
lady points out, the whole regulation only applies if A or B is met. So, on the face of it, if it's not met, the regulation doesn't apply, and Regulation 9(6) doesn't apply either. So you've got to,
Yes, yes.
You've got to do quite a lot of creative drafting to make this work.
Yes, well, certainly, I'm not making a submission that these are the best drafted regulations
No.
Ever to be enacted.
But for practical purposes, we are all proceeding. We must, depending how you leaving to one side exactly how you'd have to redraft it to make it clearer than it is, that in practice, if condition A or condition B is met, a direction ought to be made.
Yes.
I know
Yes.
it says may.
Yes.
I know there are all these difficulties, but it's the only way to make sense of it, isn't it?
Yes. The point of using the word may is rather to open up a power as opposed to contrast with an obligation. And paragraph 8, the grounds of appeal are that, in short, condition A was met, and that's enough to set aside the or have the refusal overturned. We can put it like that by the first-tier tribunal. Then we can see what the tribunal's power is. In paragraph 9, if an appeal is notified, it appears that the refusal notice should not have been issued. In my submission, that's important because first point, that looks to the time in my submission of the refusal notice. And it at least suggests that all the tribunal is concerned about is whether condition A was or was not met. And again, it says the tribunal may direct, again in my submission, there's some infelicitous drafting there, that an HMRC officer make a direction under paragraph 5.
What's the point you're making?
Well, the point there is that the tribunal, in my submission, its decision is to look back to the refusal and say, should it have been or should it not have been made? So it's actually looking back at a particular point in time. It's not taking into account further matters that may have arisen since. It's saying what should the officer have done on the basis of information available at that time, and either should or should not have made the decision then.
But surely you can't be saying by that, for example, the FTT has to confine itself to the information that was before the revenue when they took the decision, because we're in the world of condition A. The grounds of appeal are whether, in fact, reasonable care was taken, etc., etc. So surely the FTT is not confined in that way.
Yes. So sorry. Yes. It is not confined to information available, but confined to the facts that obtained at that time.
Yes.
As established by the FTT on the basis of all
But as
evidence
also
put forward.
pointed out, condition A is inherently looking at whether reasonable care, at the circumstances as they were at the time of the payment. So it's
Yes.
naturally backward looking in that way.
Yes. Yes.
What's the relevant year in Regulation 9(9)?
The relevant year, I think that is the tax year.
That's the tax year.
So 6th April to 5th April. again, I dare say that definition is in Regulation 2, which isn't in the bundle, but
It's not, I'm afraid.
oh well. It's, well, I dare say I can find that definition. Right. Moving then to Regulation 13, which is on page 44.
Just before we leave Regulation 9, and perhaps just scratching my itch, do you agree with Mr. Firth that the title seems not to correspond to the content of the regulation?
Yes, the title's a terrible title.
Sorry?
The title's a terrible title in relation to the substance of it. One can see that it has some sort of link to Condition B, but certainly there's no link whatsoever to Condition A. Again, I can ask if there is any corporate memory.
Maybe the moral of the tale is the Board of Inland Revenue should have used Parliamentary Council for these regulations.
There's not much of a connection with Condition B, because the assumption underlying Condition B is that there's nothing to recover from the subcontractor because he's paid everything.
Indeed. So in a sense, the same amount has been recovered because it has been recovered via the taxes, but it is not the same payment, the same type or nature or basis of payment. So,
but it's simply a further illustration that to look for completely coherent drafting in this scheme and in these regs in particular may be misleading. It has not been coherently drafted. That's why we're here.
Indeed, and I suppose it also illustrates the proposition that the headings of sections are not necessarily helpful in interpreting.
Well, they ought to be.
Yes.
But anyway, there we are. Okay,
yes.
Let's read you about taking us to Regulation 13.
Yes, so Regulation 13. Paragraph 2, I just note that the determination is a best judgment determination. And then, of course, paragraph 3 is the one that brings us here, that a determination under this regulation must not include amounts in respect of which a direction under Regulation 9.5 has been made. So that's point 1. Everyone is clear about that. That simply means that for Regulation 9.5, direction comes first. Any amount in respect of which it's been made can't be included in a determination. So the purpose of that part is, once you've got your...
Is what, sorry?
The purpose of that part is to say, once you've got your Regulation 9 direction, that the position in relation to the amount covered by that is final. That's it. Everyone has finality.
Can you just explain, how does Regulation 13.1a work? So there's a dispute between the contractor and the subcontractor about whether the subcontractor's contract is indeed a construction contract. And the revenue have to take a view about that, presumably.
Yes.
And under Regulation 9, Condition A might be satisfied if the contractor is correct in saying, no, this wasn't either of the contractor or the subcontractor is right in saying, no, this wasn't a construction contract. So how does that work in parallel? Revenue's got to decide first under Regulation 9, yes, the subcontractor is correct, this wasn't a construction contract, And then how
Yes.
does 13 then work? Because the revenue has already decided that it's not a construction contract.
Well,
So how can it then do anything? I
Well-
don't at the moment see how the interaction between 13(1)(a) and 9 work, where the dispute is whether the contract is or isn't a construction contract.
yes, one can suppose that the 13.1, this regulation applies if there's a dispute between a contractor and a subcontractor as to whether payments made under a construction contract or the amount of any deductible by the contractor. So one can envisage that the fact scenario this is most likely to cover is where the contractor says, I've got to deduct this money. The subcontractor says, no, you don't. I want it all. What Regulation 13.8 does then paragraph 1A applies. The contractor must make the deduction required from the contract payment of the party to which the dispute relates. And the amount so deducted is treated as a sum which he is liable to pay commissioners. So where there's a dispute, the contractor still got to make the deduction. The subcontractor can't stop that. And the amount deducted is treated as
Right.
a sum under Regulation 7 is liable.
The dispute is then decided by the TCC or whoever is going to decide this dispute, or by the FTT. I'm not quite sure who's going to decide this dispute.
Yes, well, any amount which in a final determination in subparagraph B.
Yeah,
8B.
by whom? Determination by whom?
I'm being. Yes, so I'm in direct to paragraph 6.
6.
So paragraph 1A applies.
Yes, I see.
And also doesn't make a determination.
I see. So
best
it
judgment.
goes to the FTT.
Yes.
Right. Thank you.
And then if an amount is not shown not to be payable, and it's treated as an overpayment of income tax or corporation tax to the subcontractor. So it will be paid to the subcontractor as it should have been in the first place.
Yes, so
So-
the determination under this regulation would embrace a determination of that kind. So that's not the only determination under this regulation.
Yes, that must be right. That must be right, my lord. That's in paragraph 5.
I mean, the determinations to which the regulation applies are two, which is the primary one. I'm sorry to say it was the only one I've noticed so far. That's right. Para 2, and effectively, therefore, para 6. Those are the only two kinds of determination.
Yes.
Is that right?
Yes. Well, although.
Or rather,
Yeah. So.
or rather, those are the only two provisions providing for a determination. That's really what I meant to say.
Yes. Yes, although I think that the only determination that can be made is under paragraph 2. Paragraph 2 provides for the best judgment.
Well, that's not right, is it? I mean, because para 6 is also one.
Well,
I agree para 2 is the obvious one, and as I say, I frankly hadn't noticed para 6 until this moment, so I'd assumed the structure of regulation, the actual operative provision of regulation 13 is 13.2.
yes.
And as you now point out, 13.6. Those are the only two things that provide for something to happen,
Yes. Yes.
require something to happen.
Yes.
All the rest are and then our machinery, including obviously the machinery for appeal.
Yes. So returning then to paragraph 3. The first half, there's no doubt that it's concerned with finality. And in relation to, the first half provides in relation to an amount that receives relief under Regulation 9, that amount, the final position in relation to that amount is that it is not going to be payable. My submission is that when we started talking about finality, we would expect Regulation 3 paragraph 3 to continue talking about finality. And having started with the scenario in which a direction is precedes a determination, it continues with the opposite scenario in which the determination precedes a direction. It says directions under Regulation 9 do not apply to amounts determined under this regulation. So my first submission is just that the context suggests that just as the first half is dealing with finality, so is the second half dealing with finality. And as a whole, paragraph 3 is just considering the two different chronologies which might exist. In terms of the difference of wording, again, without any express instructions, which would probably be, I'm not sure would be helpful in any event, for the draft person to be providing any evidence or assertion at that point. My submission is that, as my lord and the chair suggested yesterday, determinations and directions are of somewhat different natures. So similar to an assessment, determination particularizes an amount, which is the amount that is to be paid. The amount comes into being with the determination. By contrast, a direction it relates to an amount that would otherwise be particularized. So the amount is external. Where the amount comes from in the first place is external to the direction.
Well, wouldn't to make sense of the direction, you need to identify the amount, don't you?
Yes, one still has to.
I mean, if you're looking at the words of what the direction itself would say.
Yes, one still has. The direction still has to identify an amount, but the amount is the particularization of some or all of the liability to pay.
Would a more natural wording that do not apply? The more obvious thing might be to say, you're right, directions under that regulation may not be made in respect of amounts determined.
Very possibly, milady, and one could no doubt think of half a dozen other more natural ways of expressing the same idea. And I dare say we would all have different views as to which of those was the most
No, I
natural,
know.
the least natural.
I'm just focusing
yes.
on your point that there is a difference, which I accept, between directions and determination.
Yes, yes. But in my submission, as my learned friend accepted, the idea that different words express different things, whilst a presumption can be, I think, readily overcome with the words of Lord Sumption that my friend drew attention to in the Plevin case. And if there is any sort of reasonable explanation as to why different words are used, then that presumption is easily rebutted. My submission is that there, if one thinks of the way tax, I suppose, in a sense, works, one has an assessment tax, which is the second stage in the UK tax process. The assessment stage, that's where it's particularised. That's the determination here. I suppose somewhat unusually, a relief is granted by the board, and now HMRC, on not technical tax grounds, but on grounds of reasonable care, genuine belief, error in good faith. And that's rather different from the normal process of liability assessment collection. And so one could see there that the draftsman might have thought that this is something slightly outside the ordinary, so to reflect that, slightly different words will be used.
Well, I'm not. The result of that process is a direction of a rather formal character, the direction that then the contractor isn't liable to pay the excess.
Yes, indeed. One gets to formal direction. But certainly, in my submission, the point is that determinations particularize the amount of liability to tax, and a Regulation 9 direction relates to that amount. And whilst perhaps not the most natural wording that could be used, the words that are actually used, the directions under Regulation 9, do not apply to amounts determined under Regulation 13, is, in my submission, clear enough as meaning that a Regulation 9 direction can't be made in relation to an amount that has been determined in a Regulation 13 direction. Otherwise, there is a lack of symmetry in this provision. The first part, this common ground gives finality in favour of the taxpayer. Which is the second part, it gives finality in favour of HMRC. Of course, the taxpayer's position is that it doesn't do that somehow, and I'm not sure quite where we get to in terms of any finality. Another friend, as I understood him, ended up saying that finality is achieved by Regulation 13 determination only when it becomes final. Now, I'm not entirely sure what that means. I understand it to mean there is no longer a possibility of appeal against it, or there is a final determination.
Well, I think that's what he did say, yes.
Yeah.
But where there's any warrant for that in the legislation, I can't find.
Well, the determination is treated as an assessment. You go into the Taxes Management Act, which has provisions which contemplate how those, if an appeal is made, how that becomes final.
Well, absolutely, yes, yes. Yes, absolutely. Yes, but where it says once that's final, you can't make or where it draws the dividing line between the time you can and cannot make a Regulation 9 direction.
Well, once the determination is final, then the taxpayer's liability is determined. Regulation 9 direction would have no purpose. So, I mean, Mr. Firth's, if finality is the touchstone, Mr. Firth's structure gives you finality, surely, only at a later date.
Well,
why doesn't it?
Well, I suppose it does give finality at that later date, but not in a way that's symmetrical with.
Not in a way which
that is symmetrical with the first part of this provision, and it leaves really almost a surprisingly long time for the addressee of a Regulation 13 determination to make or to seek relief under Regulation 9.
Well, the point was made on that. I think Mr. Firth's submissions proceeded on the basis that in order, with a straight face and not to get it struck out, to actually appeal the Regulation 13 determination, you would need some proper grounds of appeal. Otherwise, it gets struck out. I think the point that's being made is that you'd have to engage Regulation 9 as your grounds, or at least part of your grounds of appeal. So in other words, it would be in play shortly after the determination, because you've got to appeal. If you're going to challenge a determination, broadly, you have to do so within 30 days. So Regulation 9 would be in play then, wouldn't it? It's not a question of, at least if you haven't got other grounds of appeal,
yes.
It's not a question, is it, of lobbing Regulation 9 in sometime later?
On another present example, in that particular example, no, but his theory did not exclude lobbing Regulation 9 in at any time.
But just to go back to the question of symmetry, which you're keen on, a determination under Regulation 13 does not give finality to HMRC because of the possibility of an appeal until it becomes final.
Well,
that's true, isn't it?
Indeed, but it does give finality
so
vis-a-vis.
Mr. Firth's backstop date, which is the date on which you can appeal the Section 13 determination, is precisely symmetrical to the date at which HMRC has finality. What's asymmetrical about that?
Well, finality as regards relief under Regulation 9. So yes, one can.
Well, the finality under if a direction is made under Regulation 9, is the date of the direction.
Yes.
Because there's no question of any appeal by anybody if a direction is made.
Yes. So if a direction is made.
Right, so even on your view, there is asymmetry then, because under Regulation 9.5, finality is achieved at the date of determination, and under Regulation 13, finality is not achieved until the expiry of time for appeal.
Well, no. Well, on other matters, that's right. So, for example, on the ground that the determination hadn't been made within the applicable time limit, because the time limits for making assessments are brought in via paragraph 5 to the question of when a determination can be made. But as regards relief under Regulation 9, my submission is that, well, that's the finality that I'm focusing on. So I should have been a bit more specific about that. But the first part is finality on those the moment a Regulation 9 direction is made, the relief is granted, that's it. Symmetrically, once a Regulation 13 determination is made, finality is likewise achieved as regards Regulation 9 relief, and it's not granted. That's it. And so in that sense, there is symmetry on the issue of Regulation 9 relief.
Yes. Anything more on
No, nothing specifically.
Para 3?
Nothing more
Or
specifically.
indeed on Regulation 13?
No, nothing more specific than that at the moment. I just said some.
Just one minor question that probably doesn't matter. Why does Regulation 13.5b only refer to income tax?
I suppose because the provisions in Taxes Management Act concern income tax and capital gains tax,
Right.
but corporation tax is dealt with in Schedule 18 to Finance Act 1998, which has slightly different rules about assessment and procedure and so on. But the 1970 Act is drafted specifically with reference to income tax issues. So,
But it's accepted that if there's a Regulation 13 determination on a company, it still has a right of appeal.
yes. I expect the word in there, they might determine where income tax is just a way of, it's a deeming provision.
It's just a way of plugging into the relevant TMA machinery.
Yes. So
your next heading was facts.
yes, next heading was facts. In the supplementary appeal bundle, my friend recently fairly went through the whole of the chronology. Tab 5, page 177. Tab 5, page 177. It's the note of the phone call between Mr. Mercer of HMRC and an agent on behalf of Beech. The caller was Mr. Loughran of Williamson and Croft, who were Beech's accountants, as I understand it, at the time, acting in relation to HMRC's inquiry into.
Yes, what's the point you want us to?
The point is simply to emphasise that halfway down, the concept of Regulation 9.4 is explained. And so, as my lord in the chair noticed yesterday, that one can see various other warnings about Regulation 9 given in subsequent correspondence before the determinations. although perhaps not strictly relevant to the interpretation of these provisions, in accordance with HMRC's normal practice, reasonable.
There's no dispute about that. I mean,
No.
this is an example of it, but as you say, this in the correspondence and everywhere. They
Yes.
were warned.
Yes.
But
yes.
that doesn't help on a point of construction. You say perhaps not strictly relevant, and it's not relevant at all, is it? Or
No, it's not relevant at all, except so far as Learned Friend sketches out all sorts of scenarios that might involve unfairness by HMRC. Whereas the reality, at least on these facts, is that HMRC did that perfectly fairly, and that's my submission to be expected of them as a public body exercising
yes.
public functions. It took just over 3 years for an application or request to be made for relief of skip
These
straight.
are, I see why you want to make these points as an advocate, but they don't contribute to the argument, do they?
No, but there's something I particularly want to look at.
Oh, I see,
in
all
the
right.
request, which is tab 44. Tab 44, page 409. No, sorry, that's the wrong one. Sorry, that's the wrong one. Tab 42, sorry, tab 42, page 287.
Tab 42,
Yes,
page
tab 42, page 287.
287. Tab 42 annoyingly is split between two bundles, so that's in.
I'm only going to look at the first page of that. So
Let me get that. Just, I don't know who's responsible for the bundles, but it always makes sense. Keep one tab within one bundle.
yes, yes.
Okay, we've got it, yes. This is the letter of the 12th of October from Preeths.
Yes, that's right. And one can see quite clearly what's been asked for is a direction under Regulation 9.5. It's under the heading Regulation 9.4.9.5.
Yeah, we can see that. I think we were showing this
Yep.
yesterday, weren't we?
Yep. And so HMRC's response at tab 43 page 407, 408. This is the letter, this is the decision being challenged.
So what's your point?
So the point here was that Leonard Friend took us to the second page,
Yes.
4.8, in the wording, therefore I am unable to give any consideration under Regulation 9.4.
Yeah.
The representative made an just to clarify his position. Leonard Friend sought to suggest that the HMRC were now departing from that.
Well, what, sorry?
We're now departing from that in my skeleton argument, which I'll come to my supplementary skeleton argument shortly. The only point I want to make here is that, of course, the context of this letter is that it's responding to a request for a direction under 9.5.
Yes.
And what is being said, my submission, if one reads it fairly, is that it's too late to give a direction under 9.5, so I can't consider Regulation 9.4, at least for that purpose.
Yep.
So that's all I want to say about that. That completes my section on the facts.
Yes.
So the third chapter was responding to Leonard Friend's preliminary points that he said arose out of my supplementary skeleton argument. And it might be of course the context of that supplementary skeleton argument was a response
Yes.
to new points raised in Leonard Friend's replacement skeleton argument. The first new point, of course, was that there is no power to withdraw an assessment. We've discussed that already to an extent, but that was the first different change of position. And the second point was responding to is broadly the problems my learned friend envisaged in his replacement skeleton argument, where an appeal against a Regulation 9 refusal is on foot. And in his submission, HMRC could thwart that appeal simply by making a Regulation 13 determination before the appeal was finally determined. My friend gets a point where he says that even in between this court hearing a Regulation 9 appeal and issuing a decision, HMRC could thwart even that part of the process by issuing a Regulation 13 determination then. So that's the context of my supplementary skeleton argument. So, with that in mind, if I look first at paragraph 17, I said the appellant's position now in their replacement skeleton argument is that there's no power to withdraw an assessment without making an appeal to an HMRC officer, and thereby opening up the possibility of withdrawing assessment under the provision for a review or Section 54 of the Tax Management Act 1970. And that therefore the High Court's decision in this case was wrong so far as based on the idea that possible abuses or other injustices, I'll come back to that, could be reversed easily because the collection management powers would allow withdrawal of Regulation 13 determination. So paragraph 17 concerns the situation. Not only do HMRC let it be assumed to have no power to withdraw, but also a determination also have no power to decide not to collect any money under a regulation determination. Does that cause the various problems that my learned friend identifies? My submission there is that the problems my learned friend identifies all arise from the making of Regulation 13 determination.
Sorry, the problems that he identifies all do what?
All arise from the making of a Regulation 13 determination in the course of an appeal against a Regulation 9 refusal. A Regulation 13 determination is, of course, subject to the usual public law requirements. It's an act by a public body in the exercise of public functions. So far as there is no appeal against it, there is always recourse available to judicial review.
Really? You would have had an alternative remedy.
Well, so as far as the appeal doesn't...
The proper remedy, if you disagree with the determination, is to appeal against it, not to go for judicial review.
Well, as far as the appeal allows one to raise grounds, so the tribunal's jurisdiction doesn't extend to, for example, legitimate expectations
Okay,
or
so
abuse of power.
right, I see. So you.
Sorry, I wasn't
understand.
hugely clear there. So I apologise. Now the two scenarios my learned friend relied upon were Regulation 13 determination that is made quite deliberately by an HMRC officer in bad faith to thwart a Regulation 9 appeal. Now that is obviously amenable to judicial review.
Sorry, make that submission again.
So if a Regulation 13 determination is made in bad faith by an HMRC officer to thwart a Regulation 9 appeal, then that's quite plainly amenable to judicial review.
And unless and until it's set aside on a judicial review, does it have the effect that North Point says it has, that it deprives the FTT of jurisdiction to consider the Section 9(5) appeal?
Well, in my submission, no. And what and one has to look at North Point in its context, which was that the Regulation 13 determination was made at the same time as the refusal to make a Regulation 9 direction was communicated to the addressee. So North Point only concerns, in terms of its ratio decidendi, concerns only a scenario in which a Regulation 13 determination has been made before an appeal has been made to HMRC, a review request has followed that, and of course an appeal to the tribunal follows that.
But nonetheless, if I've understood it, North Point has the effect, if correct, that you can't appeal that refusal notice. The FTT hasn't got jurisdiction.
Yeah, where the Regulation 13 determination is made before the appeal commences. But my learned friend's examples of problems all involved a Regulation 13 determination being made after an appeal process is on foot.
After what, sorry?
After an appeal process is on foot.
But, sorry, I may be misunderstanding you. The facts in North Point illustrate a problem, don't they?
Well, they show a problem where, well, potentially a problem, but not the problem that our friend identifies in his replacement skeleton argument, or focuses on his replacement skeleton argument. Because my other friend looked at Regulation 13 determinations made either in bad faith or to protect a time limit from expiring. My proposition is that both of those scenarios are not the end of the world for the addressee or the appellant, because both can be dealt with by judicial review.
Well, he said the latter one couldn't be.
Yeah, indeed, but in my
Why was he wrong?
Sorry?
Why was he wrong to say that you couldn't judicially review a determination made to avoid time running out?
Well, because the basis of the determination is that there was HMRC were right to reject the Regulation 9 request for relief, whereas the tribunal's decision on a Regulation 9 appeal, as we saw from Regulation 9 paragraph 8, is that the request should not have been refused. So the request should have been granted, and therefore it's an error of law for HMRC to make a Regulation 13 determination on the basis that the Regulation 9 request was correctly refused.
So that transfers to the administrative court, effectively, the appeal against the refusal, even though the statute says you appeal to the FTT.
Well, in my submission, it at least provides machinery. In my submission, it doesn't deny the tribunal jurisdiction at that point in the appeal. The tribunal's jurisdiction is not somehow ousted in my submission. Because we're supposing that the tribunal did have jurisdiction when the appeal was started. In my submission, North Point can't go so far as to say the tribunal's jurisdiction is somehow ousted halfway through the appeal process.
So you've got to have this dispute determined twice, once in the administrative court and again in the FTT?
Well, the Regulation 9 provides for the tribunal to determine whether the request should have been
Yes, but the
refused.
Regulation 13 has now been, determination now been issued to protect the time limit, and you say, oh, well, you can deal with that by judicial review. So you go off to the administrative court and you say, well, HMRC made an error of law because HMRC should have given me the 9.5 direction. That's the very same issue as is being considered by the FTT. And it seems bizarre that there is a statutory scheme which requires two different courts or tribunals to determine the same question.
Well, one would anticipate that in a reasonably normal way, the matter would be determined by the first-tier tribunal, and the judicial review would be stayed pending that,
I thought the whole point was that you couldn't have a 9.5 or direction under 9.5 if you've got an extant Regulation 13 determination. So to stay the judicial review leaves the Regulation 13 determination in existence unless and until the court sets it aside. So where's the FTT's power to require HMRC to make the direction?
Well, my submission on that is that the FTT's makes a decision as to whether the tribunal, as to whether the request for relief should have been granted.
So one decides a preliminary issue on that question, then you go back to the administrative court, say, well, look, this is what the FTT's decided, so please quash the Regulation 13 determination. And then you go back to the FTT and say, look, the High Court's quashed the Regulation 13 determination, so now you, FTT, can require HMRC to make the 9.5 direction. It works like that?
Well, one would expect parties in the judicial review to simply settle the matter and, if need be, agree an order for the court to make, having the effect of quashing the determination. Whether thereafter it's necessary in fact, inevitably, on the facts of a determination made to protect the time limit, it is inevitably not necessary for any Regulation 9 direction to be made, because the time limit for making a determination has expired. Without a determination, HMRC cannot collect an amount of money. So it remains the position that the tribunal needs to make only a decision on whether the grounds of the Regulation 9 request, reasonable belief, error in good faith, or genuine belief, reasonable care plus error in good faith or genuine belief are made out, and everything follows from that. And it's not the intractable difficulty that my other friend suggested is. It does take a reasonable degree of cooperation between parties, which would be expected by submission. Oh, sorry, I hadn't noticed the time.
No, I was waiting. It didn't seem fair to interrupt your submission on this point, but have you made your submission?
Yes, I think I made my submission at that point.
Well, then we will rise. 2:05.